Welcome to Pretty Lies and Alibis. Let's seek the truth and travel the long road to justice together. What you know, Alibiers, welcome to another episode of Pretty Lies and Alibis. I'm Gigi, good to have you here. It is Thursday, Friday Eve, October 17th. Hope you guys have had a good day so far. Don't forget to hit subscribe, like the video, and ring the bell if you want notifications of when I go live or post new content. Appreciate all y'all. I've gained a ton of subscribers just in the past week, so thank you so much. We are going to jump right in because this is lengthy and I'm going to get through all of this. There was another filing with this. It was over 100 pages, basically telling the history of the case. We don't need to get into that. I assume if you're watching, you pretty much know the history of the case. If you don't, I have a whole series, so you can look under my playlist. So let's start. Motion to relinquish jurisdiction to the trial court. Now it says the appellant like 50,000 times. I'm going to say Charlie Addison. Charlie Addison, by and through undersigned counsel, moves the court to relinquish jurisdiction in this case to the trial court and alleges, number one, Charlie is appealing his convictions following a jury trial for murder, conspiracy to commit murder, and solicitation to commit murder. Charlie was sentenced to life in prison. Charlie is one of several persons charged with the murder of Dan Markell. Prior to Charlie's trial, 3 other people were convicted of the murder of Mr. Markell. After Charlie's trial, but before his sentencing, another alleged co-conspirator, Donna Adelson, Charlie's mother, was indicted and arrested for murder. At his trial, Charlie was represented by attorney Daniel Rashbaum, Esquire. After Charlie's sentencing, Mr. Rashbaum appeared as counsel of record for Donna Adelson in her case. On September 11th, 2024, the state issued a subpoena on Charlie for him to be a state witness at Donna Adelson's upcoming trial. Shortly thereafter, on September 17th, 2024, Mr. Rashbaum withdrew from Donna Adelson's case after the trial court, the Honorable Stephen Everett, questioned him about the conflict of interest that existed due to his current representation of Donna Adelson and his previous representation of Charlie, who was now a witness in Donna's trial. Then, on October 7th, 2024, the trial court disqualified Donna Adelson's other defense lawyers from her case on the basis of Mr. Rashbaum's conflict of interest. They cite from that decision by Judge Everett. It says the withdrawal of attorney Daniel Rashbaum became necessary when he engaged in a conflicted representation falling short of the ethical obligations for members of the Florida bar. Upon further consideration of the September 17th record and the in-camera proceedings with attorneys Daniel Rashbaum and Robert A. Morris, a sufficient ethical wall was not established. Thus, the conflict of interest involving privileged information or communications has been imputed to Robert A. Morris. Additionally, this case is rife with the potential for the same conflict as to Adam Commissar. They cite Colker versus State and Kanta versus Philip Morris. Unimputing a conflict seems as implausible as unringing a bell, unscrambling an omelet, or pushing toothpaste back in the tube. They talk about Florida bar. It imposes on all Florida attorneys an ethical responsibility to refrain from engaging in conduct intended to disrupt a tribunal and conduct which is prejudicial to the administration of justice. While the defendant retains a presumptive right under the Sixth Amendment to her counsel of choice, that right is not absolute. See Wheat versus United States. The presumptive right under the Sixth Amendment to counsel of choice cannot interfere with the fair and orderly administration of justice or the court's authority to monitor and control the pace of litigation. Both federal and state courts have repeatedly made clear that the right to counsel cannot be manipulated so as to obstruct the orderly procedure in the courts or to interfere with the fair administration of justice. They cite Bowman versus the United States and Bundy versus State. Florida Supreme Court holding, there is no absolute right to a particular counsel when there is a countervailing public interest in the fair and orderly administration of justice. The fair and orderly administration of justice cannot be maintained when conflicted counsel or counsel with the potential of conflict cannot meet the standard of serving as constitutionally effective counsel. And they cite Culker, which explains trial courts have an institutional interest in protecting the truth seeking function of the proceedings over which they preside by considering whether the defendant has effective assistance of counsel, regardless of any proffered waiver. Furthermore, the danger to conflict free proceedings was not cured by Daniel Rashbaum's withdrawal. Prior to the selection of the jury, Charlie filed a notice indicating his non waiver of any conflict of interest with Daniel Rashbaum. Robert A. Morris then filed a response in which he advised a third-party counsel had been retained to resolve any actual or potential conflict of interest. In a reply to this response, Charlie Addison objected to Morris or a third-party counsel cross-examining him. The Third District Court of Appeal, when reviewing the disqualification of counsel in Culker, disagreed with the proposition that an actual or potential conflict could be avoided by having substitute counsel conduct the cross-examination of a former client. The Culker court further explained the conflict arises from the past relationship and cannot be avoided by sectioning off portions of the trial. The potential for conflict would remain, as would the appearance of impropriety. Absent judicial intervention, at this point, delay to the fair and orderly administration of justice will be at risk of repeating itself. Without the establishment of a sufficient ethical wall and the fact that even third-party counsel cannot avoid the potential for conflict, the court cannot permit Robert A. Morris or Adam Commissar to remain as counsel of record, nor will the court permit this situation to continue. Accordingly, for the reasons above, attorneys Robert A. Morris and Adam Commissar are disqualified from further representation of the defendant. Against this backdrop, undersigned counsel believe that Mr. Rashbaum's conflict of interest also infected Charlie's trial. During the course of their representation of Charlie, undersigned counsel learned that Mr. Rashbaum represented Donna prior to the arrest of Charlie. Stated another way, Mr. Rashbaum previously represented a co-conspirator in the same or substantially related manner, and he had an actual conflict of interest during the course of his representation of Charlie. Notably, Donna Adelson was listed by the state as a Category A witness in Charlie's case. Subsequently, Donna Adelson was listed as a defense witness for trial. Ultimately, Donna was not presented as a witness during Charlie's trial because she was removed from the defense witness list days before the trial was to begin, after the state sought to interview her. Undersigned counsel assert that Donna's removal from the witness list was done in order to protect Donna's interests, in other words, not being interviewed by the state, and against Charlie's interest, which is a witness that could have corroborated Charlie's testimony, was not called by Mr. Rashbaum. Hence, Mr. Rashbaum's representation of Charlie at trial, after having previously represented Donna Adelson, constituted an actual conflict of interest. They have a footnote here in its rules regulating the Florida bar entitled Conflict of Interest. Former client states the following: a lawyer who has formerly represented a client in a matter must not afterwards, A, represent another person in the same or a substantially related matter in which that person's interests are not materially adverse to the interests of the former client unless the former client gives informed consent. B, use information relating to the representation to the disadvantage of the former client except as these rules would permit or require with respect to a client, or when the information has become generally known, or C, reveal information related to the representation except as these rules would permit or require with respect to a client. As explained by the 11th Circuit Court of Appeals in Porter versus Singletary, An attorney who cross examines a former client inherently encounters divided loyalties. Given the recent finding by the trial court in Donna's case regarding Mr. Rashbaum engaging in a conflicted representation, falling short of the ethical obligations for members of the Florida bar. Charlie asserts that the same principle applies to Mr. Rashbaum's representation of him, Charlie, at his trial because Attorney Rashbaum was operating under a conflict of interest based on duties owed to his former client, Donna Adelson, whose attorney client relationship predated Charlie's. Documents supporting the statements set forth in the previous paragraph are included in the appendix to the motion, and the documents establish the following. The murder of Dan Markel occurred in July 2014. In 2016, the probable cause affidavit naming Sigfredo Garcia Rivera and Katie Magbanawa, Charlie and Donna Adelson as co-conspirators was released. In 2016, attorney Daniel Rashbaum was Donna Adelson's attorney for purposes of the investigation into the murder of Mr. Markel, as evidenced by his signature on the Adelson family statement. In 2022, Charlie was charged with the murder of Dan Markel. Mr. Rashbaum filed a notice of appearance on May 9th, 2022. Charlie did not validly waive the conflict of interest involving Mr. Rashbaum's representation of him at trial and Mr. Rashbaum's prior representation of Donna Adelson, who was listed as a witness by both the state and the defense. A review of the record on appeal establishes that a conflict waiver inquiry was not conducted by the trial court. They cite Lee versus State. This court articulated that requirements of a valid waiver of the right to conflict-free counsel. For a waiver of conflict-free counsel to be valid, the record must show the defendant was aware of the conflict of interest, that the defendant realized the conflict could affect the defense, and that the defendant knew of the right to obtain other counsel. On September 22nd, 2023, Donna Adelson, Mr. Rashbaum's former client, was listed as a state witness for Charlie's trial. Also, on September 22nd, 2023, Donna, Mr. Rashbaum's former client, was listed as a witness for the defense for Charlie's trial. In October 2023, Mr. Rashbaum withdrew Donna Adelson from the defense witness list in Charlie's case after a hearing in which the state sought to compel Donna Adelson's interview. In October through November 2023, Charlie was tried and convicted while represented by Mr. Rashbaum. In November 2023, Donna Adelson was indicted and arrested for the murder of Dan Markel. They quote, I'm going to butcher this name, y'all, Larzellery versus State. And notably, in Lee, the court found the defendant and defense counsel had an actual conflict of interest because defense counsel had recently represented one of the state's witnesses. Defense counsel had an actual conflict of interest resulting from his own prior representation of a key witness against the defendant and the public defender's recent representation of that witness. November 2023, recorded conversation leading to Donna's arrest. Donna discussed advice she had received from Mr. Rashbaum regarding whether she would be able to leave the country undetected prior to being arrested for the murder of Mr. Markel. They quote Donna, look, we have to make a decision at some point. After speaking to Dan this morning and knowing what they're thinking up there, I don't know if we'll make it out in time. I really don't, because Dan said you might, or you might do all of this, get to the airport, and they'll stop us. And that could happen. It could happen. I don't know, but it's worth a try. And I swear, y'all, I think it's my video. I could be wrong, but I copied and pasted and it came to my page. Could be a fluke, but that's crazy if true. In December 2023, Charlie, represented by Mr. Rashbaum, was sentenced. In January 2024, Mr. Rashbaum appeared as Donna Adelson's defense counsel for trial. In September 2024, Charlie was subpoenaed as a witness for the state for Donna's trial. In September 2024, Mr. Rashbaum withdrew and/or was removed from Donna Adelson's case by the trial court on the eve of jury selection on the basis of Mr. Rashbaum's conflict with Charlie. In October 2024, the trial court, on its own motion, removed the remaining defense counsel for Donna Adelson on the basis of Mr. Rashbaum's conflict of interest and the lack of a sufficient ethical wall. Accordingly, in light of the foregoing, Charlie intends to file a motion in the trial court raising this conflict claim against Mr. Rashbaum, who represented Charlie at trial while owing duties to his former client, alleged co-conspirator, and listed witness Donna Adelson, to whom he continued to provide legal advice regarding her own involvement in this case while simultaneously representing Charlie. Because Mr. Rashbaum's conflict of interest in Donna's case was just recently considered and ruled upon by the trial court, undersigned counsel submit that it would be in the interest of judicial economy to allow the trial court the opportunity to immediately consider whether the same conflict infected Charlie's case. The trial court is uniquely situated to decide this issue, having previously presided over Charlie's trial and now presiding over Donna's trial, and because the trial court was recently apprised of the conflict issues involved with these lawyers and parties. Charlie therefore requests the court to relinquish jurisdiction to the trial court for a reasonable period of time so that he can file a motion raising this conflict issue. Charlie respectfully suggests it would be a more efficient use of the judicial resources to address this matter immediately, because if the trial court grants this motion, then the instant appeal will become moot. They cite another case where the Florida Supreme Court considered the question of whether the pendency of a petition for writ of, this word is pronounced two different ways, and I'm going to say certiorari, in the Florida Supreme Court, arising from the affirmance on direct appeal of the judgment and sentence, deprives the trial court of jurisdiction to consider a Florida Rule of Criminal Procedure motion to vacate filed after certiorari petition has been filed in the Florida Supreme Court. The Florida Supreme Court held that the trial court was deprived of jurisdiction to rule on the motion to vacate while certiorari proceedings were pending in the Florida Supreme Court. They have a footnote here. Alternatively, by allowing the trial court to consider this matter, it may allow this conflict issue to be also considered on direct appeal. However, at the conclusion of the opinion, the Florida Supreme Court stated the following: our holding, however, does not preclude defendants seeking an order from the appellate court to temporarily relinquish jurisdiction to the trial court for the purpose of filing and being heard on a motion to vacate prior to the appellate court's disposition of the case. This is the practice now utilized in the appellate courts in this state. See Jacobs versus State. The filing in the appellate court of a request to relinquish jurisdiction, however, does not require an appellate court to automatically relinquish jurisdiction to the trial court. The proceedings in the appellate court may be nearing conclusion, and therefore the appellate court may not wish to relinquish jurisdiction at the time of the request, but it might prefer to proceed with the disposition of the cause. This is within the discretion of the appellate court to decide. Further, the appellate court, before relinquishing jurisdiction, may evaluate the grounds for the motion to vacate to determine whether they are frivolous and may decide not to relinquish on this basis. This denial of the request to relinquish, however, is not a ruling on the merits of the motion to vacate and will not prevent a subsequent filing of a motion to vacate with the trial court at the conclusion of the proceedings in the appellate court. They cite some case law in two different cases about a remedy suggested. In Jefferson, while the defendant's direct appeal was pending, the court entered an order of temporarily relinquishing jurisdiction so that the defendant could pursue a post-conviction relief. It's a legal procedure in Florida that allows a person to challenge a criminal conviction and request relief, which is exactly what Charlie's doing here. The court stated that the following procedure applies when such relinquishment is granted. In Combs versus State, authorizes relinquishment of jurisdiction to the trial court when counsel informs the appellate court of an honest belief that there is an issue as to ineffective assistance of counsel. That opinion, as well as State versus, probably going to butcher this, y'all, Meneses, appears to us to contemplate that the proper procedure to follow when such relinquishment is granted is to file a motion for post-conviction relief pursuant to Florida Rule of Criminal Procedure. If the trial court does not grant the relief, a new notice of appeal may be filed. The original appeal may proceed if there are other issues and should be dismissed if there are not. As our order in this case stated, jurisdiction was relinquished for collateral proceedings, for instituting proceedings separate from the trial and pending appeal. However, no such motion was filed. Instead, the trial court and the parties apparently relied on the allegation in appellant's motion to relinquish. While this procedure was not in the technical compliance with our order, we entertained the appeal by treating the proceedings below as having been conducted pursuant to remand for hearing upon an application for a new trial. They cite other case law, one cited in Combs, in which the Supreme Court remanded for testimony in the trial court on application for a new trial. Under Florida Rule of Criminal Procedure, ineffective assistance of counsel may properly be raised as grounds for a new trial. The issue in this case, having been thoroughly aired before the trial court, is now sufficiently preserved and presented for our review, and the appeal from the judgment of conviction is carried over for that purpose. They cite Libby versus State. Accordingly, we affirm the trial court's denial of appellant's motion without prejudice to appellant, number one, filing another such motion after his present appeal has been decided and has become final, or two, as recognized in Meneses, seeking an order from this court to temporarily relinquish jurisdiction to the trial court for the purpose of being heard on this motion. It says emphasis added, Wright versus State. The proceeding was conducted in the trial court while the appeal was pending here, pursuant to our express relinquishment of jurisdiction for that purpose. They refer to other cases where these motions to relinquish jurisdiction was granted. Then they say, pursuant to these cases, Charlie requests the court temporarily relinquish jurisdiction to the trial court so he can raise his conflict claim. Consideration of the factors set forth in Meneses and Jefferson establishes that relinquishment is appropriate in the instant case, i.e., the current direct appeal proceedings are not nearing conclusion as the initial brief has not yet been filed. Charlie's conflict claim is not frivolous, and undersigned counsel have an honest belief that there is a credible and good faith basis for Charlie's claim. Moreover, Charlie submits that it serves both the interest of justice and judicial economy by having the trial court address Charlie's claim at this time, since the conflict claim was just considered by the trial court in Donna's case. Undersigned counsel have contacted opposing counsel who has indicated that the state needs additional time to consider its position. Undersigned counsel will file a supplement indicating the state's position, or the state will file a response. Wherefore, for the reasons set forth above, Charlie requests the court to temporarily relinquish jurisdiction to the trial court so that he can raise his conflict of interest claim. That's the end of the filing. We'll keep an eye on this. Again, I'm going to link STS's episode from last night on this that gives a good insight into what we're dealing with here, which is pretty big according to several attorneys that have done YouTubes on it. And like I say, a couple say maybe not time to panic yet. The new trial is granted. There's a lot of things that could be done differently too. Would Charlie take maybe a possibility at parole if it's offered to throw his mom and his sister and anybody else under the bus? We will see what happens with this, but Lord have mercy, y'all. I woke up this morning and saw that tweet and I was like, what in the world has happened? It's just, but you can't be surprised anymore. And at the end of the day, the people that are suffering are Dan's parents, Dan's sister, everybody who knew and loved Dan, because are we starting over? Maybe they'll try Donna and Charlie together. That would be worth a watch. We'd have to pop a lot of popcorn for that one, but I'll keep you guys posted on anything new. We will see you soon. Have a good rest of your evening.